And so, I mean, this is an issue that, although we're talking about Liberty Safes and we're talking about this specific case on cell phone data, applies to so much that touches our lives in 2023.
We are the Armed Attorneys. Today we're talking about a really important concept for gun owners, and this relates to third-party search doctrine. When can these companies, corporations, and businesses turn over your private records? And what spurred us to kind of talk about this was the Liberty Safe debacle. We'll go over that in a second. But before we begin, show your support for the Second Amendment by hitting that like button. And today's video is brought to you by our friends over at Sonoran Desert Institute. Check them out at sdi.edu/armed-attorneys. They have online gunsmithing, armor courses, so much more. Take your hobby to the next level with Sonoran Desert Institute. Now, Liberty Safe, I think we can say safely that they shat the bed on this one.
Yes. Wait, are we going to get YouTube punished for that? Come on, Richard.
No, we don't need to censor that. If you haven't heard the story yet, you've been hiding under a rock. Essentially, Liberty Safe, longtime safe manufacturer, provided the FBI a code to get into a person's safe. They had a warrant to search the premises. They didn't have a warrant to Liberty Safe or a subpoena to Liberty Safe or a court order to Liberty Safe. They just said, hey, Liberty Safe, will you turn this over? Yep. They said, here you go. And so obviously and expectedly, folks very, very upset at Liberty Safe's behavior because, what is supposed to be safer than a safe? Why do they call it a safe?
Yep, sure enough.
And I think that's kind of a side to kind of what we want to talk about today, which is what does the Supreme Court say when it comes to reasonable expectation of privacy with these kind of records that are held with third parties, right, corporations, and companies?
So let's go back in time, if you will.
Yeah.
Let's go back in time to mafiosos, which, God, we end up talking about mafia times a lot because that's where a lot of our gun laws come from.
Yeah.
But third-party search doctrine, right? Cue like law school memories of like waking up surrounded by highlighters and sticky notes. And we're talking about this fundamental issue that although the government has to, upon probable cause, have a search warrant issued in order to search anything in which you have a reasonable expectation of privacy, you can voluntarily provide information to third parties, and the government doesn't have to get a warrant for that. And this came up a lot when they were trying to prosecute mafia guys, and they were using their bank records, basically, yep, and things of that nature, essentially saying, you don't have an expectation. You gave this information to the bank. You gave this information to, this random third-party guy who's flipped on you, mafia dude. And so we don't need any sort of, there's no legal standard to obtain that information. You voluntarily provided it to a third party. That means that just per se, you have no reasonable expectation of privacy because you gave that information away. Now, fast forward to, the age in which we are all constantly giving away our information because it's the only way to function on the internet. Like, you can't have nice things unless you give away a certain amount of information. And we have all sorts of problems in that the government still thinks they can go get anything they want, right?
Yeah. Enter a really important Supreme Court case that I think it's important for gun owners to, keep in the back of their mind. Typically we're talking about big, New York State Rifle and Pistol Association or Heller or any of these other great Second Amendment cases. This is a Fourth Amendment search case that, in order to kind of be a functioning member of society, you have to understand a little bit of Fourth Amendment law and Fifth Amendment law and, all of these things. But
you got to know when the government's trying to take advantage of you.
Yeah, exactly.
I mean, if you don't protect your own rights, who's going to do it?
Exactly.
The government's not going to do it for you.
No.
I mean, we try, but you got to get in trouble and hire us. So, yeah. I mean, but yeah, you got to know. You got to know.
I've seen that in the comments. People get in trouble just so that they can hire you.
Oh, that's so sweet.
But we're talking about Carpenter v. United States. If you want to check this case out, it's 138 Supreme Court 2206. This is a 2018 case, and this had to do with cell location data. In this case, we have 4 guys who were suspected of some robberies. The federal government, under what is called the Stored Communications Act, obtained cell site location data, and ultimately, Mr. Carpenter convicted. He had tried to get all the cell data kicked out of court because he said, hey, look, I have a reasonable expectation of privacy.
I mean, in my literal location, right? I mean, the government would have to get a warrant in order to put a tracker on your car.
Right.
But not to get your location data from your cell phone provider. It's crazy.
Yeah, it is. It is pretty crazy. And for that Stored Communications Act, the standard that the courts apply in that case are reasonable grounds that the records were relevant and material to an ongoing criminal investigation. not probable cause
Mm-mm.
that you would expect, a higher standard that you would see in a warrant.
Yeah.
So ultimately convicted, he appealed. They tried to suppress all of this evidence. They lost there, appealed it to the Supreme Court. And what did the Supreme Court hold?
So the Supreme Court said that you do, in fact, have a reasonable expectation of privacy in that information, which means the government can't get it without a warrant, which is super duper. And you would think in 2018 that they might have extended this somehow to help us a little bit more, but they did not. This was a very, very narrowly tailored decision. However, we are seeing it come up all the time, and it will be instructive when it comes up again. I mean, I will say, as much as I get really annoyed that my husband will not let me plug the Alexa in because I just want to ask it questions and I want to know things and I want to know what the weather is and I want to make it play music. And he's like, no, because it's listening to you all the time,
Yeah.
which,
Have you ever seen Alexa data? It is
yes,
horrifying.
I know. Well, but look, but if someone murdered me in my house,
Sure.
it's going to record that.
There you go.
And then they'll, no, but I don't. Anyway, that is the Alexa murder issue, right? Is that this happened very recently with Amazon Alexa. Alexa actually recorded a murder in progress. And, it sort of cued everyone into this idea that Alexa is always listening. But do you have an expectation of privacy in that kind of data? And the answer to that is the same as your expectation of privacy in your own safe and your expectation of privacy in your cell phone data, which is, yes, it's happening within your home. Of course, you have a reasonable expectation of privacy that the government needs to respect. And so, I mean, this is an issue that, although we're talking about liberty safes and we're talking about this specific case on cell phone data, applies to so much that touches our lives in 2023. I mean, the third party doctrine is just, it's going to have to almost go away based on how we live our lives today, I think.
Yeah. And Emily, talking about this pre-show, I mean, there's some important notes here. Does this only apply to the Stored Communications Act? Are we only looking at this on a federal level? We see a lot more warrants issued on a state level as
Mhm.
opposed to a federal level. So there's a whole lot
Yeah.
of nuance here that I don't know that we could cover in kind of this brief discussion. But ultimately, what you need to know is the Supreme Court said, yes, there was a reasonable expectation of privacy in the cell data. The government needed to have a warrant based on probable cause. The government didn't get a warrant based on probable cause, and therefore, this information was wrongfully included in the court's record, wrongfully included in evidence, and they remanded the case, reversed the conviction, and
Right.
remanded it.
So back to Liberty Safes. If Liberty Safe simply provides your information sans warrant, is that going to be suppressed? Yes, because I think that you're providing this information to Liberty Safe, but you have a reasonable expectation of privacy in your safe, which
Yeah.
I think means anything that happens without a warrant is shot, suppressible, done. So,
Yeah.
I think that's the important note here, just to bring it on back.
Yeah, well, and Liberty Safe, they had a humongous backlash. They tried to ameliorate. They issued a try to half-hearted apology
Mhm.
slash we will try to do better. And Emily's a little bit not as hot on this as I am, but here's what they said, and I think it's worth talking about. We have also revised our policies around cooperation with law enforcement. Going forward, we will require a subpoena that legally compels Liberty Safe to supply access codes, but can only do so if these codes still exist in our system. So Liberty Safe did a couple of things. One, they said, hey, we can delete all these backdoor codes, and if you
Mhm.
stored codes with us, and you ask us to expunge that stuff, we'll destroy them from our records. But also, we're not going to turn over things unless a court asks them to through a subpoena. I don't think that actually goes far enough, and I know Emily disagrees with me a little bit here, uh, but because we look at the standard in Carpenter, they make it pretty clear you need to have a warrant based on probable cause. Now, it's hard. You put yourself in the shoes of this business owner. They receive a subpoena or a court order saying, "Give us this stuff." What are they supposed to do? Tell the court to go pound sand? And I think, there's legitimate concerns there where I think Liberty Safe should go further. A court order, that doesn't necessarily mean that it's based on probable cause. Subpoenas usually are based on just a material need.
Mhm.
And so I don't think that those meet the standard that are set up by Carpenter. If I was Liberty Safe, I would go a step further and say, hey, we're not going to turn over this stuff unless we are served a warrant. If we're served a subpoena, served a court order, we're going to try to quash those things. Those don't meet the threshold. Our customers have reasonable expectations of privacy. So I think they should go a little bit further. And I don't necessarily think we get there with just the, hey, the court asked us for this stuff. I know,
That's fair.
yeah, but it's tough. You're a business owner. You got the federal government. You got a court order in front of you.
Yeah, that's what bugs me a little bit
yeah.
is like, in a perfect world, do all the businesses we provide data to fight in court to protect our data?
Yes.
Absolutely. Realistically, could, you know, is it their job to expend lots of money in attorney's fees to protect me? Could that hurt the corporation generally? I don't know. I guess I got some sympathy for that. Like, that's my criminal defense attorney, sure as hell better fight for me.
Yeah.
But is it the corporation's job? Do they just hand over data from subpoenas? I don't know. I'm just not as hot.
The last consideration I think that is worth discussing, and we've talked about this before, is let's say you got a warrant served on your house. Maybe it's even as specific as, hey, we get to search and seize the contents of your safe, whatever safe that is. A question that we always get is, do I open the safe for law enforcement? Do I make them rip it apart in order to access it? What should I do under those circumstances? And to answer that question, it comes down to a couple of things. First, if you open the safe voluntarily and there is a defect in the warrant, I think there's an argument that could be made that, hey, look, you open this thing voluntarily. It doesn't matter what defects there were in the warrant. You have voluntarily granted consent to search. And so therefore, if there was any illegally obtained evidence, that gets rid of the taint of the illegally obtained evidence. And so I think there's an argument there. But what happens if you don't give them access to it? Well, they're going to completely destroy your safe. Some of these safes are very, very expensive. Is the government going to have to pay you back? Let's say they ultimately lose the case against you. No, they have qualified immunity. So you are going to be out one very expensive safe. But I think what a lot of defense attorneys will say is it is best practice to not interfere with a search, but not necessarily help them, discover incriminating evidence against you. But that's just the last thing that I think is worth talking about. And we've talked about that in the past. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please question and comment for us below. Let us know what you think about how we should be protecting your private data in this very, very different world we live in than we did when initially we were talking about search warrants and the like. Until next time, we're the Armed Attorneys. Both of us were like, what in the was that?
And then I'll kick it off.
What's safe?
Yeah, what is safe?
Are you safe? The answer is no.
They're coming for you.